What are my rights during a mass layoff? Imagine this. You arrive at work like any other day, but instead of your normal shift, you and dozens of co-workers are told the company is shutting down or cutting staff. The doors are closing, jobs are gone, and you start asking, what are my rights during a mass layoff? Mass layoffs are devastating, and they raise tough questions. Does your employer have to give notice? Are you entitled to severance pay? What happens to your health insurance or retirement plan? Can they choose who gets laid off without breaking discrimination laws? The truth is, federal law, especially the WARN Act, and many state laws provide important protections in large-scale layoffs. At the same time, employers often try to cut corners. In this video, we'll break it all down. Notice requirements, severance rules, benefits continuation, discrimination protections, and what steps workers can take if they're caught in a mass layoff. The WARN Act, Advance Notice Requirement. The Worker Adjustment and Retraining Notification Act, WARN, is the cornerstone of mass layoff law. It requires certain employers to give 60 days advance written notice before a plant closing or mass layoff. The law applies when the employer has 100+ full-time employees. 50 or more employees are laid off at a single site within 30 days. Or 1/3 of the workforce at a site is laid off, if that's at least 50 workers. If the employer fails to give notice, workers may be entitled to back pay and benefits for each day of violation. Example: a factory with 200 employees lays off 80 without notice. Under the WARN Act, the company may owe 60 days of wages and health benefits to each affected worker. Exceptions to the WARN Act. Not every layoff triggers WARN protections. Exceptions include faltering company. If giving notice would prevent the company from securing capital to continue. Unforeseeable business circumstances, such as a sudden market collapse or pandemic-related closures. Natural disasters, like floods, earthquakes, or wildfires. Even with exceptions, employers must still give as much notice as possible. Example: a hotel closes after a hurricane destroys the property. The employer may qualify for the natural disaster exception, but must still notify workers as soon as practical. State, mini WARN, laws. Many states go further with stricter versions of the WARN Act. California, WARN, requires 60 days notice for employers with 75+ workers and applies to smaller layoffs. New York, WARN, requires 90 days notice and applies to employers with 50+ workers. New Jersey, WARN, requires severance pay in addition to notice. Example: a tech company in New York lays off 60 employees without notice. Under New York WARN, workers are owed 90 days' wages, so depending on your state, protections may be stronger than federal law. Severance pay, law versus practice. Contrary to popular belief, federal law does not require severance pay. Unless an employment contract, union agreement, or state law requires it, employers don't have to provide severance. But many companies offer severance to reduce lawsuits. State laws like New Jersey's WARN Act require severance. If severance is offered, employers may ask workers to sign a release waiving certain legal claims. Example: a retail chain offers 2 weeks of severance pay if employees sign a waiver of claims. Workers can choose whether to accept. Health insurance and COBRA mass layoffs often mean loss of employer-sponsored health insurance. Under the COBRA Act, Consolidated Omnibus Budget Reconciliation Act, employers with 20+ employees must allow workers to continue health coverage for up to 18 months, though workers must pay the full premium. Employers must provide a COBRA notice within 14 days of the layoff. Some states have mini COBRA laws that extend coverage. Subsidies may be available during national emergencies, like the COVID-19 pandemic. Example, a laid-off worker receives a COBRA notice offering coverage at $600 a month. It's expensive, but it ensures continuity of health care, retirement benefits, and pensions. If you have a 401k or pension plan, you keep any money you contributed. Employer contributions that are fully vested also remain yours. Non-vested contributions may be lost if you leave before vesting. Employers must provide plan documents under ERISA, Employee Retirement Income Security Act. Example, a worker with 15 years in a pension plan is fully vested. Even after a mass layoff, they keep their pension rights. Discrimination protections in layoffs. Layoffs cannot be used as a disguise for illegal discrimination. Title VII prohibits discrimination based on race, sex, religion, or national origin. ADEA protects workers 40 and older from being targeted because of age. ADA protects workers with disabilities. Employers cannot retaliate against union activity under the NLRA. Example, a company lays off mostly women in management but keeps men with less seniority. That may violate Title VII. Even in a mass layoff, the selection process must be fair and non-discriminatory. Overtime, final pay, and state payday laws. When a mass layoff happens, employers must still follow wage laws. FLSA requires prompt payment of all earned wages, including overtime. State payday laws. Many states require final pay immediately or within days of termination. Employers cannot withhold final pay as a penalty. Example, in California, a laid-off employee must receive their final paycheck, including accrued vacation, on the last day of work. Real-world cases. Case 1. In 2023, a large tech company faced lawsuits after failing to provide 60-day WARN Act notice during mass layoffs. Workers sought back pay and benefits. Case 2. A New Jersey employer paid both notice wages and mandatory severance under the state's WARN Act after laying off 150 employees. Case 3. A manufacturing plant in California closed suddenly. Workers won damages because the company didn't provide WARN notice. Case 4. In an age discrimination case, older employees were disproportionately laid off. Courts ruled it violated the ADEA, despite the employer calling it a reduction in force. These cases show that even in layoffs, workers can and do win when laws are violated. What workers can do. If you're caught in a mass layoff. 1. Ask about WARN notice. Was proper notice given under federal or state law? 2. Check severance offers. Don't sign away rights without understanding the terms. 3. Review benefits. Look into COBRA for health insurance and request retirement plan documents. 4. Watch for discrimination. If older workers or certain groups were disproportionately affected, that may be illegal. 5. File complaints. Contact the U.S. Department of Labor, the EEOC, or your state labor agency. 6. Seek legal advice, especially if large benefits are at stake. Example, a group of workers laid off without notice files a WARN claim together and wins 60 days of back pay. The bigger picture mass layoffs can happen quickly, but workers are not powerless. The WARN Act, state laws, and anti-discrimination statutes provide real protections. Employers cannot simply shut the doors without notice or selectively target certain groups. Workers may lose jobs, but they don't lose their rights. Knowing these rules helps workers protect wages, benefits, and dignity during one of the toughest moments in a career. So, what are your rights during a mass layoff? Federal law under the WARN Act requires 60 days notice for large employers, with state laws often adding more. You may not always get severance, but if it's promised, it must be honored. Health insurance can continue under COBRA, and vested retirement benefits remain yours. Layoffs cannot be used as cover for discrimination, and final pay must be delivered promptly. The bottom line: a layoff takes away your job, but it doesn't erase your legal protections. If you face a sudden mass termination, check your rights, document everything, and don't hesitate to file complaints. If this video helped clarify things, share it with coworkers. Knowledge is protection, and in mass layoffs, it can mean financial survival.